we have. So what do we understand by what data protection is? Anyone wants to say their understanding? Yes? What is data protection? Anyone know what a data subject is? I've mentioned it. So, a data subject, it refers to any individual, person who can be identified, directly or indirectly, via an identifier such as your name, your ID number, your location, or factors specific to your person, your physical appearance, physiological, genetic, mental state, economic, cultural, or social identity. So that's a data subject. And in a nutshell, a data subject is you and I. When we are relating with the Sacco, we're the data subject, right? Because they collect our information so that they can grant us services, they can give us services. Who is a data controller? A data controller is any person or entity that determines the purpose of collection of data. And then we have a processor. So when we look at the Sacco is the data controller. The member is the subject. When you look at a data processor transfers, organizes, and processes personal data on behalf of a data controller. So the processor, in this case, we would look at your core banking system in the Sacco. We would look at your mobile application. That platform is processing, it's doing something to your data subject's data. So the owners of that platform would be referred, or the company that runs the platform would be referred to as the data processor. Yeah? Then we have the data commissioner, who is Ms. Immaculate Kasait. She's the commissioner in charge of the Office of the Data Protection Commission. And she's the person who is relevant for ensuring that issues around data protection are properly supervised and enforcement of the provisions of the law are carried out. Then there's a term people always talk about, data protection impact assessment, DPIA. You always hear people say DPIA, DPIA. So what is a data protection impact assessment? It's basically a risk assessment to look at your personal data that you collect and identify what you do with it, processing. Does it have any risks towards the data subject, towards the member, by you collecting the information, by you checking them through the Credit Reference Bureau? What risks occur in that process of checking through the Credit Risk Bureau? So where the law states very clearly that where a high risk on processing is identified, then you need to conduct a data protection impact assessment, and there's a well-defined process on how to do it, and submit it to the ODPC's office before you start processing. Or if it's something you're already doing, you submit it, and within 60 days, they then come back and inform you whether it's okay to continue or what measures you need to put in place so that you can continue with your processing activities. So, what is privacy? Privacy is an individual's right of freedom from intrusion or prying eyes, or the right of the person to be left alone. So, constitutionally, as per Article 31 of the Constitution, we all have a right to privacy. We all have a right to being left alone. And what is personal information? or personal identifiable information. Personal information is that information we can identify an individual. It can be your name, your ID, your location, where you work, or your ID for work, your browsing behavior. You accept cookies when you access certain websites. They're collecting your personal information. So that is personal information, but what is sensitive information? So sensitive information is information that can potentially put you at a risk of discrimination or abuse. When you think about it, in the Sacco space, my statement of savings, of loans, that's sensitive information. Yeah? It's sensitive information. So, or you can talk about sexual orientation. If you're in Uganda and you say, this is an example I know that's usually important. If you're in Uganda and you're gay, so to speak, you're gay or you're a homosexual, and it's known by the government, there are certain implications that go with that. So that is extremely sensitive information, which I guess as a Sacco you don't really need to be collecting that because it's irrelevant for you to do your core business of collecting savings and giving loans. So there's a difference between data protection, or rather data privacy and data security. The law about data protection looks more into privacy, into guarding your privacy when you're interacting with organizations. So it's more concerned on the proper usage, collection, retention, deletion, and storage of personal data. But data security is about the policies that are in place, the methods and means to secure your personal data. And that, I think you had a long discussion this morning, or information this morning about that. Just to bring it closer for your understanding is, you guys know who that is? You know this guy?
Zuckerberg.
Yes. So, imagine you built your house and you don't put any windows. Do you think your house, you're safe in your house? Are you protected? Are you protected if you have no windows in your house? No, you're not protected, sorry. You're not protected. What about if you put the window, then you have some level of protection, right? But do you imagine that you're safe? Or your privacy is being adhered to? If you're doing something in the house, if this guy comes and looks, and you have a window, will you be able to see what you're doing? So, the curtain here is what provides privacy. If you want to think about data protection, you need to think about it in that sense. The windows are giving you security, and the curtains are providing some level of privacy, because once you close the curtain, nobody from outside can see what you're doing. So what is a data breach risk? And what is a data breach? The data breach can be classified into, for you to remember, I usually say it can be classified into CIA, confidentiality, integrity, and availability breach. Those are the type of breaches that exist. So what is confidentiality breach? It's when an unauthorized or accidental disclosure of or access to personal data occurs. So I'll give an example. Maybe at your Sacco branch, your teller is sitting there and they leave their laptop open and somebody comes and, disclosure. So if someone comes and requests, my name is Barasa, but there's a Barasa with a Z, and requests for their statement. and then I get the statement for Barasa instead of Barasa. So there's a confidentiality breach that occurred because it was accidental. It wasn't intentional for that person to receive my statement or Barasa's statement. Availability breach. It's an accidental or unauthorized loss of access to or destruction of personal data. So when you look at there's a practice a lot of banks do. I'm not sure if the Sacco space also does it, but where they're upgrading their systems, if they're upgrading their core banking system or doing something to their system and you won't be able to access your mobile or internet banking, you're supposed to, by law, actually disclose that we will be down for the next 24 hours, you will be able to access this service. That is something you're supposed to do. So if you're found not to be doing that, that's a data breach and somebody can report you because they're in distress. It's a Friday evening, they need to access their money. You need to inform them that there's an upgrade and they can't access it. So they can report you to the office, the ODPC's office. Then when you look at integrity breach, it's any unauthorized or accidental alteration of personal data. So I'll use an example my colleague loves to use. He's called Makobi, M-A-K-O-B-I. When he goes to hospital and at the counter registration, they'll collect his name, Paul Makobi. And he sits. There's usually triage and the next process and the next process. So by the time he's getting to actually see the physician, the doctor, he's been called Paul Makori. Because Makobi is not a very common name. So they're calling him Makori. Somebody changed the B to R. That's an integrity breach. And he can report when he goes to any doctor's place and they do that. He can report it because it's distressing. Why are you calling me Makori and I'm Makobi? So the law has clearly defined those as breaches. The person who asked about breaches, are we okay now? Do we appreciate what a breach is? It was somewhere on this side, right? Is he still there? She? No? Okay. Any question?
If somebody called me 0 with an A, is that a breach?
Okay, let me continue. I don't know why that screen is not working. This one is working. I don't know what's going on.
It was interesting, yeah? Because I think I can choose a few guys around. I think it is interesting to me because I think I can get a few bucks somewhere here. Hapa too. Some people call me 0 with an E, while my name is 0 with an I.
Oh.
So can I see them?
We can have a chat on the side and talk about what we can do about that. So, as I had mentioned earlier, the Data Protection Act was passed on 25th of November 2019, and the Data Commissioner, Ms. Kasait, she was appointed in November of 2020. So the Data Protection Act, it gives effect to provisions of Article 31 of the Kenya's Constitution, which provides for the fundamental right to privacy, and it's largely modeled around the European Union's GDPR. Something I did mention earlier when I was differentiating between privacy and security, being data protection, is that in Europe, they refer to privacy as data protection. And because we have modeled our law around it, we also refer to it as data protection. When you go to the Americans, they refer to data protection in terms of privacy just as data privacy. So I might use the terms interchangeably between data protection and privacy, just so that we are all on the same page. I'm talking about the same thing, protection and privacy. So the principles, These are the core things. I'm going to explain what the principles of data protection are and the data subjects then next. The principles of the Data Protection Act. The first one is lawfulness, fairness, and transparency. So personal data must be collected and processed in a legal and fair manner and have a legitimate basis for the processing. Yeah? Organizations are required to inform the data subject that they are collecting the data, the purpose they are collecting, and who the third parties are. So when I say third parties, that's the data processors I had mentioned. Whoever you share that information with as the Sacco, who gets access to that information. So a data controller has the duty to consent, to get consent. You have to get consent from the data subject when processing personal data, and individual rights of the data subject must be protected. So what he talked about, okay, so lawfulness, fairness, and transparency. Now, the other principle is around data minimization. As a Sacco, I'll also use Sacco to refer to controller, just for today's purpose. As a Sacco, you must minimize the information collected, and it needs to be for the purpose of collection defined, and not collect excess information. I'll go back to the example of sexual orientation. If you're, or religion, when you're onboarding, unless you're a religious Sacco, based Sacco, and there's a reason for that, when you're onboarding your members, you only need to collect the information that you need for the purposes of giving them that. If you collect their sexual orientation or religious, sexual preferences or religious background, it has nothing to do with savings and credit. So it's not necessary to do that. And then confidentiality and integrity. So personal data is subject to data secrecy. Yeah? It must be treated as confidential on a personal level and secured with suitable organizational and technical measures to prevent unauthorized access, illegal processing or distribution, as well as accidental loss, modification, or distribution. So you have to secure your members' data. You have to secure it as the board, custodians of the Sacco. Then the purpose limitation principle. It's about personal data can be processed only for the purpose that was defined before the data was collected. Any subsequent changes to the purpose are only possible to a limited extent, and they require substantiation. So if you collect the information and you want it only for savings and credit, and then your marketing guys decide, we have this new mobile loan, and we need to publish and send information on SMS, on email. If you had not said you're going to be doing that, and you do that, that's a breach, and you can be reported to the data commissioner for not limiting purpose, or rather sticking to the purpose limitation principle. Accuracy, personal data on file must be correct, complete, and if necessary, kept up to date. Suitable steps must be taken by the Sacco to ensure that inaccurate or incomplete data is deleted, corrected, supplemented, or updated. So if I came and told you my name is not Barasa with a Z, you need to go to your records and correct it so that it's Barasa with the S. And if my date of birth had been captured wrongly, I was born on, say, 12th of January, 19 whatever, but then your records show, because of different people who write dates in different ways, Americans and British, you captured it as I was born on 1st of December. You alternate those two. If I notice there's a difference in that, you need to correct it. Storage limitation. Once the purpose of the data collection is complete, you as the SACCO needs to delete the data unless there's a good reason to keep it. So if by law, like CBK mandates financial institutions to keep data, I think, for 7 years, if there's another law that requires you to keep it for longer, then you can. But as long as the purpose for collection is complete, then you need to destroy or stop storing the data. Accountability. All the data controllers, all SACCOs, all data processors, anybody who processes your data shall be responsible for personal data protection and should be able to demonstrate compliance to these principles, all the principles here. So the accountability is about everything here. All these 1, 2, 3, 4, 5, 6. You have to be accountable to your data, subject to your member for adhering to those principles. Sorry. So data subject. So I said, I think these 2 slides were a bit of the heavy slides, and then after that, a bit of a relaxed one. So data subjects have rights. You as a SACCO member, you have rights. You have a right to transparency. You have a right to understanding. How was it that I applied for a loan for 300,000 and then it came back and I've been given only 150,000? You have a right to understand what process went into that. If the SACCO does not expose that to you as a member, you can report them. Then access. You have a right to access your information. I had a scenario where my son kept falling sick. He has sinuses. So he kept falling sick and I kept taking him to a specific provider. I don't want to tarnish him, but I took him to this provider. Maybe in a span of 4 months, it could have been 8 or 9 times. Homa after homa, every other week, and they were giving him antibiotics constantly. So it troubled me and I was advised, okay, you know what, go to a different provider and see if they'll diagnose differently. And see, actually, there's a different diagnosis. What's happening up there in the ENT. So I went back to the clinic and I requested, can I have the data that you've been giving me? Because yes, you diagnose, but then I don't know what you're diagnosing. I would like to have all that information so that I can go and look at it, even analyze it for my own appreciation. The provider refused. They refused to give me the data. I felt like it was too much work to go and report, but I have a right to access that information. It is my child's information. It is our personal and sensitive information, but they didn't provide it. So that's someone I might want to go report. Do you think I should go report?
Sure.
Yeah? I will. So that's what access is. You have a right to access your data. You have a right to correction. I think I mentioned about correction before. You have a right to erasure. If you don't want to work with this provider anymore, you have a right to tell them, erase all my records, erase all my data, unless, of course, they are bound by a different law to keep data for a certain amount of time. So for me, I could have gone and told them, okay, you know what, I'm not happy with your services, erase my information and prove to me that you have erased. If you cannot prove, I'll go and report you. So we have those rights as data subjects, as members of the SACCO, as citizenry in this country. Any service provider you have, Safaricom, whoever it is, the SACCO, you can actually get that, your insurance company, you have a right for that. Objection. You have a right to object on the processing of your data, further processing of your information. And then portability. You have a right to decide, I'm not happy at IG Sacco, I want to move to maybe Mwalimu Sacco. You have a right to actually get your statements, get all your records and your behavior that they have and migrate with it. So they give you all your files and you migrate with it and you go and tell them, Mwalimu Sacco, this is the character I am, this is how I handle my finances, and I would like to be accepted in this SACCO. That's your right as a member. Do you have any questions? Any comments? So, I want to share with you a case. The cases are publicly available on the Data Protection's website, Commissioner's website. So these are not secrets that I'm revealing. There was a case of a gentleman who took a loan with NCBA, Mr. Bernard. He took it and he put his wife as a guarantor for the loan. And along the way, him and his wife disagreed and they separated. So he went and requested NCBA to remove her and not to share any of his sensitive financial information with them. But then they went ahead and continued looking for him to pay. So if he fell back on a loan, they would send the ex-wife messages and inform her that your loan is in default. Yet he had requested for them to stop. So NCB actually had an issue on data management. What do I mean by that? They had the records, but they changed some of the information in different systems. You know, you will always have siloed systems. You have your banking platform, you have your SMS system, you have your what, and it seems like they didn't change the record in all the systems. So what happened is the wife still got these messages, and it really did not sit well with him. So he went and reported. He reported and he was awarded 700,000 shillings because they were not actually listening to him and doing what he wanted. So there were issues around consent. The wife didn't want to receive this. She didn't consent to them sending them those things, and they were still doing it. And he had a right to object, actually, the further processing of the information to go to the wife. So that's the case of NCBA. Non-compliance is extremely costly, and in Kenya, the penalty is 5 million, up to 5 million or 1% of your turnover. We've seen that Bernard got 700,000. And that's one case. So you can imagine if there are many other cases that come similar to that, how much money will the SACCO lose if the SACCO actually is the one that's in breach. Then an individual, you as the SACCO CEO, you as the board members, you're responsible to ensure that the SACCO is compliant. If it's not compliant, then you as the individual, or if it's found a breach occurred because of your negligence, as an individual you can go to jail for 10 years, or a penalty of 3 million shillings, up to 10 years. GDPR fines are really high, and they separate them by, or rather the difference between theirs is that they use the personal and sensitive data. So if it's personal information that was breached, then it's up to 10 million euros or 2% of the annual turnover. I think theirs is whichever is higher. And then for sensitive information, it's 20 million or up to 4% of the annual turnover, whichever is higher. Risk and privacy. What do these things have to do with each other? Would anyone disclose if your SACCO members have actually reported? Do your SACCO members know their rights, by the way? The ODPC's office is educating them. So, what has privacy got to do with risk? Privacy, it's the DNA of business risk. Why do I say that? Your members are their information is your most valuable asset. And anything happening to the membership will create panic to the rest of the members. Then there'll be a migration, like what happened to Chase Bank. So what is the right fit for privacy? I think or which department, which function should handle data protection, data privacy. Should it be the ICT? Should it be the legal? Or should it be risk department that handles? Or should it be all? So the law talks about you must have a data protection officer in your Sacco. Whether it's somebody who sits there all the time or it's an outsourced resource, but there must be a data protection officer. And this person will handle, they'll handle the policies, they look at what policies you have in place, they look at ensuring that the policies actually adhere to what the law says, they look at the processes that you do, is it what the policy says? You're doing a certain process this way, but the policy says you're supposed to be doing it this way. They look at that, they look at ensuring there's awareness in all the staff, and then they look at systems. How are the systems compliant? So, if you ask me, I would say a good function would be somebody who has knowledge about risk, because they're able to look at the policies, they're able to look at the processes and the systems and see what controls are there that have been put in to ensure that there's compliance happening. What's the link between risk management and privacy? Well, data privacy and protection, they're closely linked to managing the risk, since a fundamental driver of risk management is to safeguard the company's objective. So privacy is an enabler in terms of keeping information, both personal or corporate, secure. Any loss of this data, it exposes the Sacco to various risks. Some of the risks you're being exposed to strategic risk. So the companies drive business through strategies on the basis of trust. Trust is a key currency of our future. A customer who trusts you will be willing to work with you. The member who trusts you will work with you and will also refer you to other people. We'll be happy to refer you. So any loss of trust, maybe through failure of established privacy mechanisms, can expose the company to some irreparable strategic risks. We have reputational risk. NCBA has already been seen to be in breach. Will everybody want to deal with them? Or what is the reputation now that they've been fined? We have financial risks. You lose money from litigation, you lose money from the administrative fines, you lose money from compensation from a data subject, like the 700K. And then you also have legal risks. If you don't enforce any enforcement of privacy regulations due to failure to comply, it carries fines and citations for corporate entities. No, I think we're sleeping. Maybe. Any questions? Any comments? Yes.
Question at the back. Okay.
Okay, Asante. My question is on the information about a person and the data. For example, recommendation, or we can say a living certificate. And the person in office is supposed to write to recommend a staff who is living or a student. And what you recommend in the office is more about that person and his data. I write, you are not good, like that, and I sign and I give you. Or I recommend anywhere, then I will give you. Is that not a breach of the information about a person? And this person can go to court. He exposed my inner being. in a form of other. How do we go about that? The other thing is disclosures. As institutions, we disclose some information. But I think these institutions are also legal-headed. If, for example, I disclose an expenditure incurred by some of my board of directors, am I not breaching a data? And am I not doing something which is very dangerous? So I should not disclose to anybody or authority an expenditure incurred by some of my people. How do you cover that? Because sometimes you are told exposed to this, like that. How do you go about it? Thank you.
Any other question? This table looks like they have a question. Do you guys have a question? Says thank you for now.
Alright, so maybe I'll answer the gentleman. From my understanding, a bad recommendation, right? It's a bad recommendation. Yes? So, the bad recommendation, can you substantiate that bad recommendation? What happened when this person was in the entity? Did they have a case? Did they go through disciplinary action? And when they were going through that process, there's always documentary evidence to show what was happening. So if you go report, I've given you a bad report, and it's the truth. I don't think there's anything wrong with that because I'm actually disclosing the truth. I am not lying because I can substantiate that with the documentation of the process, the disciplinary process. So that's on bad recommendations. And then on disclosure of expenditure by the board. The question is, who would you be disclosing it to? Because again, when you're looking at the Sacco and its operations, you have policies on your expenditure. And you're supposed to disclose certain information, you're supposed to stick within the budget. There are certain things that are not allowed. So as long as it's within your financial policy, your finance policy, I do not think there's anything wrong, especially if it's being disclosed within the board meetings, it's being disclosed in your financial statements, because that's where it's supposed to be disclosed, and it's correct. Yeah? Okay.
Okay.
Any other questions, comments?
Any other question, comments? Any other question, comment?
Paul has something to say.
Paul.
Maybe to add on to what I've responded.
Okay, Paul.
So on disclosures, the two questions, I'll start with the last one just to add a bit more on what Mercy said. She started off and defined the data subject, defined the controller. The Sacco is a controller. One of the things she mentioned was accuracy. Then she mentioned purpose. As long as you're working within those parameters of why you collected that data and you're using it for the specific purpose, it is all right. And yes, if you go to the determined cases, you'll find many cases around the same subject where you change the purpose. I collect your personal data. All of you are data subjects, by the way, your employees or your members of your board, and the Sacco knows information about you. So the policy normally should cover that part, how we handle our personal data, how we handle our financial data, which, by the way, financial data falls under the category of sensitive data. Sensitive means the law requires you to be more stringent on how you process and handle it. So as long as it's within the purpose, the reason why you collected it, then it's okay to exchange it. On the references, bad or good references, yes, as she so rightly said, you answered correctly, or you gave an accurate picture of what you are asked to give. And actually, if you give wrong information, the same person can go around and actually sue you for giving inaccurate information. Because the law expects you to have accurate and exchange accurate information. That's a quick top up on what you say.
Okay, that is a good addition. Any other question? Any other question? You look curious, sir. Do you have a question or a comment? You know you have glasses. You must have a comment. You can't have glasses and fail to have a comment. It's okay. Back to you.
Thank you. So how do the SACCOs perceive privacy, but organizations in general? Sometimes laws, when they come in, people feel like this thing is coming to impede our business, our activities. So how are we going to operate now? It will interrupt how we usually do our business. So there's a real general reluctance to understanding what the provisions of the law are. And this bundle, they bring some sort of nuisance to the business. How do you overcome that challenge? First, we need to get a full understanding of the law. It's really critical to work with the legal department for interpretations, but then also we need to train also, once everybody understands, then train the business on the provisions of what the law is saying and emphasizing on, what are the good things about this law. Training levels to the board. So you might be a few board members in one SACCO here, but it's really critical for you to then go and champion the agenda of privacy because of the risks that you have seen exist. So we need to, another challenge is that when it comes to compliance, is people want to just check a box. They want to say, okay, we comply. People think that when they register with the Data Protection Commissioner's office, then they are compliant. But compliance, again, I say, it's a journey. It's a process. So it's really seen as a nuisance to the organization. And people just want to do policies and move on and not do much. But you need to, as champions in the board, after this training, we need to highlight what are the benefits, especially in business, that will try to get your customers. Yeah? What are the benefits? If you guys say you're data protection compliant, if you're working towards ensuring your systems are able to give the data, the members, their rights to migrate their data, to change their information, I mean, they'll be very happy to continue dealing with you. So those are the benefits that you want to also highlight rather than it being just a compliance issue. So, is the signature at the bottom of an application form enough to say that the member is consenting you to check their credit with the CRB? Is that signature enough? Is it? It's enough. So on the form it says we are going to, as we process your loan, we will check with the Credit Reference Bureau. It says? Okay, so that signature is enough. That's good. But so if the person doesn't want the loan anymore, can they stop you from checking with the CRB? How do they do it?
By counseling.
they just cancel, and it's usually okay. So you also want to just look at how do you implement these things around that consent. You want to look at that and how to overcome issues where, like in NCBA case, the guy said stop sending to this lady and it continued going. So you want to look at that and ensure that those are things that become a culture. So it's also very expensive to comply. People think or say it's expensive to comply. But is it really expensive? If compliance will cost you, what, 2-3 million, but then you say it's expensive and you want to leave that money to distribute in dividends, and then at the end of the year you get complaints, 5 to 10 complaints, each of them is awarded $1 million. Will compliance be expensive? It's not. So it's just a misconception, and I think it's important to implement ways, technical and operational measures to comply. So, why is privacy a critical part of risk management? Yeah? It's not just a compliance obligation, but it's also strategic. I mentioned why it's something strategic. So I think organizations should really prioritize privacy and effectively manage any associated risks that are likely to attract and retain customers or your members in an era where privacy concerns are at an all-time high. Privacy is really big. Think about what last week, was it last week that the paper said how our information with Safaricom is not safe? Are we happy about that? Or what do we think about now, do we take an extra thought process before we use our phones, before we send M-Pesa? But we are okay. It's okay if we're monitored. Privacy-centric risk management, it's not only protecting your individual's privacy, but it's also mitigating those legal and financial risks when establishing a very strong foundation for trust and competitive advantage. You know, once you're able to understand your membership, once you're able to understand the demographic, how old are they, who are they, then you really are able to tailor products for them. If they're mostly Gen Zs, those guys want instant things. So if you're not doing a mobile service loan, you're already back. If they can't contribute by just sending the money from their mobile phone, it's a problem. So it's so important when you actually comply to this law, you go to in a process where you understand your membership, and you're able to create these products for them. So what's your role as the board members, as the leadership for the Sacco space? You need to understand the provisions of the law. It's really important. I know I've said it before, but it's an important thing. Once you understand, then what is the background, what is the training you need to give to the Sacco, to the membership, what are the funds you need to allocate for this activity. Yeah? You need to embrace it as a board responsibility. You need to get to the level like where Sacco is at, and they're reporting on privacy in their financial statements. When you look at your ESG, environmental, social, and governance policies, are you reporting? Are you reporting on those things? You need to report on your privacy, on your compliance status as well, because it hits your finances if you have a breach. It hits your finances to comply. Those are important things. Then you need to appreciate the benefits of complying with the law. As I mentioned, you understand your membership, you create better products. You're able to serve them better. If someone is in distress, you're able to see this is I can look at this member from the time they joined to this time, 20 years later, and see there's something actually not right, and be accommodative of their situation so that you can serve them better. You need to have a clear roadmap and allocate the budgets, as mentioned. So I'm going to mention the roles of the data protection officer. It's a requirement in the law. Then there's the role of the information security officer or manager, and then the role of the heads of departments in the Sacco. So the data protection officer is responsible for informing and advising the Sacco or the processor on their responsibility and obligations based on the data protection laws. The DPO is also supposed to monitor compliance based on what the law is. There are regulations that are being published continuously by the ODPC. They're supposed to inform the Sacco on what's going on. They're supposed to assign responsibilities. They should on what needs to be done for compliance. They need to provide training. Training is a very big thing. Many organizations that had registered with the ODPC, registration is coming up. Renewal of their registration is coming up. So they need to be able to, and the ODPC is checking, what are the awareness levels? What are you doing in your Sacco? So when you renew, you need to tell them the awareness levels and even provide a roadmap of the implementation. So the DPO should be able to do this for the Sacco and also advise the staff on how to conduct that risk assessment I mentioned, the DPIA. They should work with all relevant persons to protect the personal data and guide the organization towards being compliant to the law. They are also the liaison. They're the people who are responsible to respond to any queries from the ODPC's office. That's what the DPO does. It's a very important role, and it allows for you to either have it internally or have it outsourced, but you need to appoint a DPO within your SACCOs. Then there's the role of the information security manager. These two people, they don't do the same role, and it would be advisable not to give that DPO role to the information security manager, simply because the independence will no longer be there. So what does the information security manager do? They report to the management on all security matters on a regular basis, and then they communicate the information security policies to interested parties, and they ensure that the documentation of the security controls is properly in place. They quantify the types, volumes, and impacts of security incidences that occur. This is specific to what the speaker in the morning was talking about. So the security manager is in charge of ensuring safeguarding of information, then defining the improvement plans and targets for the financial year, and monitoring your performance. How many breaches did you have this year vis-a-vis last year? What are the mechanisms you're putting in place? Is it working? Do you need more budgets? And implementing any recommendations that the DPO's office puts. So the data protection officer needs to look at all departments. They need to look at security of your data, members' data. If they identify any issues, then the implementation of, say, encryption of data will be done by the security manager's office, information security manager. So then you have your heads of department. What is their role in data privacy? They review and manage employee training needs to prepare them to perform their tasks. and then they communicate and ensure that the employees within the organization are aware of the importance of the activities in relation to data protection. So as a head of customer service, your head of customer service has to know that they can't just give a statement to a delegate because the delegate came to the office saying my member is not well, print for me their form. Print for me their statement or send me their statement and for onwards sending. They need to be aware of those things so that they don't expose the organization, the Sacco. So contributing to the data protection impact assessment, the DPO will not know how customer service operations go on, but he can advise them on ensuring that they are conducting the proper risk assessments and ensuring now when they conduct the risk assessment, what comes out of it, are they able to tell that delegates are being given information without the correct authority or are being exposed to data. If the delegates are being exposed, then the DPO then would advise on mitigation of those issues, probably by training. Then the HODs need to also implement all the recommendations of the DPO's office. So we have one of our clients, the data protection office did an assessment on how they conduct their activities, recruitment. So how they conduct recruitment. And they saw that there were a lot of risks because they were collecting data and through Google Forms, this goes to a third party. When it's going to a third party provider, then there needs to be certain agreements in place. So they conducted an assessment and walked the journey of from the time the applicant is applying online to the time that they are being interviewed and how the information is destroyed, and they gave recommendations on how to do that, which would need to have policies in place on how that data is managed, and then now an implementation process. That's an example of what HODs need to do. So what challenges are there in the implementation journey? I don't have too many more slides, I'm about to finish. So the challenges we have is privacy is not really understood. I think there was even as late as early this morning, a misunderstanding of what security is and what privacy is all about. So many SACCOs, many entities imagine that when you talk about data privacy, it's an IT issue, it's an encryption issue, it's a password issue. It's not. It is a culture around protecting the rights of your membership to be left alone. Then there's a lot of talent wars in this journey. So you'll see maybe a security manager wanting to be the data protection officer. But if they do that, then there's no chance that there's going to be independence because the security manager buys encryption and then again he wants to assess whether that encryption is something helping them to comply. Then there's a very intensive undertaking. When you look at the journey, when I don't think I described it well enough for you to understand and appreciate the journey that Sacco went through and still going through. I hope you appreciate that it's a very intensive undertaking and it needs resources allocated to it. The human resource budgets and all. Then there's a lot of volumes of data for sure for you as SACCOs. You have a lot of data. And just managing all that information can be mind-boggling. So it creates a lot of challenges around that. And then privacy is really about a culture. It's really about appreciating that if a delegate comes to me and asks for a statement for so-and-so, I'm not just going to expose the information. I need to appreciate that there are certain processes and I adhere to them. So it's a culture change and it's something that's done continuously, day in, day out. It's That's a challenge, but it needs to be done. There are very many benefits you can get from investing in a data protection program. So you definitely won't have the issues around compliance. If the Office of the Data Protection Commission comes to you, you're able to show them your roadmap, and it then allows you to do your core business, which is credit and savings. And then reputation. So if a case is brought against one of your SACCOs and you're able to manage it and prove, or you're able to demonstrate the way that you're trying to protect information, most likely you won't get such a big fine, so it won't be in the papers and create anxiety among your membership. It also creates some competitive advantage. So when you've aligned and agreed and seen how your data looks like, by the time you're creating those products, appreciating each member as an individual, it creates some trust and grows the business, grows the Sacco business. So we're able to mitigate the long-term risks. I've talked about this, and prevent the data breaches, the CIA. You're able to ensure that you're not getting caught out. And then you're able to operate efficiently. In my case of my doctor, they would have just been able, if they had really adhered to the act, then my file would be there available for me, and they would just go into the system and print it without any issues. So, what is the significance of the Office of the Data Protection Commissioner? Their main mandate is to create awareness to the general public so that they're aware of their rights. And once the membership is aware of their rights, in case of any issues, they'll be able to file complaints. That's something important you need to remember. So the ODPC's initiatives raise a lot of awareness about privacy and the need for robust risk management. It also increases accountability for organizations to ensure compliance. They're an independent oversight body, and in as much as people think that their core business is to punish and penalize people, I think they're working towards just ensuring good levels, or a standard level of compliance within the country. Because we are not landlocked data-wise, we deal with other entities. And as a country, if our levels of compliance are at a good level, then we're also able to trade with foreign countries without issues, because we are adhering to certain standards. Any questions? Yes. And any comments?
Finally, the table that I believed in. I think I saw the seed. Now it's bearing fruit. So, you can say your name, then you point your question.
My name is Daniel Kenyon, Mareta, CEO Solutions. My question goes to recently what has happened to one of the banks. And there was a breach, and people withdrew money, and that money has found itself in a number of our accounts. Our members have found into their accounts with us, and the bank has written to us, and they request us to be refunded directly. Now, if we comply to that, then these members have a legal application to us. Should we demand that we have a court order or a court process that secures our position, or we can comply and cooperate with the bank directly, and the members come have a litigation against us. Thank you.
Yeah, that's Very good one. It's related to either money laundering, okay, in this case money was stolen and burnt with yourselves. So you have the data privacy law or act does not stay or stand on its own. It has, and it works with all the other laws already in existence. So if there's an overarching law that says matters financial are managed under the act of the central bank, in your case maybe anti-money laundering or money from crime, then that law will overact over the privacy. Now, the right of the individual, your account holder, is not absolute. But it's only not absolute to the extent where there is a law, because the issues like if you look at your employees, you have to file their pay to KRA. You have no control over that because there's another legal law which overrides, and you cannot ignore that law. So in your circumstance, you basically need to check with your legal which law overacts which one, because the privacy, my right to my private data is not absolute. If it's not legal, if it's a crime, those are some of the processes that the law then allows you to exchange that data. If it's an investigation, if it's a legitimate government investigation, then you can reveal. Now, to transfer, I think you'll have to check with the laws of how do you return money which is under investigation or it's been stolen. It's not a privacy matter in that case.
Satisfactory? Okay. Question?
Yeah, I'm just asking, we are entities, if you have data in your possession for one purpose, but then you use the same data for another purpose which is not the one that was intended, does it breach the act? Just like the government had their data about LHIF and it was used to maybe change to SHA.
Okay.
A very good question again, and it's reality, at least the message of data privacy is getting home. So, the law and the principles, when she talked of principles guide why we are building the law, and in there the principles help a normal human, a normal operation aligned to the law. So the 8 principles were laid out, and among the principles was purpose. You define the purpose, then it changed along the way. Specifically in the case of share shift, definitely there is issues similar to what happened, and I think there might be processes in court already. What happened to Huduma number? All those were stopped simply because of the data privacy law. So in the case of shift, NHIF to shift, the law should have captured that. If the act allowed that, then it was overtaken by the new law that the data has to be transferred. Now, what's our responsibility as the people holding data for these members of ours, assume it's an employee within the Sacco, then it's a thing to inform and update them that this has happened. But if a new law is formed that overrides the existing, it doesn't say the privacy law has been suspended, it only says this specific data has moved to another government agency who are legitimately responsible to process that data. That's a case of share shift. But in the cases where they've stopped several laws happening, even the KRA Financial Act 2024 had a component of accessing data beyond your KRA data going into your M-Pesa and Safaricom and all that. That was already in court by the time it was being brought down in Parliament. So it's a process ongoing, and that's one of the reasons why it's not a fix. As laws change, you might need to realign your business to just be safe and secure. Because, yes, people are paying penalties simply because they were out of sync with what was happening at that particular time. So I would say, yes, share shift, NHIF to share shift, I think it's captured under the Act. So it's like saying, going forward, we're transferring your data to KRA or a new agency that is handling revenue collection. So it's still within the law.
Okay.
There's a question?
Thank you. My name is Finley. My question would be around the consent.
Yeah.
As the Act specified a certain format for members within different institutions to consent on that issue of the data. And two, is there a threshold that would say, by way of signing the document, the customer has accepted to that? And thirdly, on the same, would we say that since the Data Protection Act came into force just a few years ago, what happens to the existing covenants between customers and institutions? Do you go and introduce writing consent forms so that they can consent over the same?
I'll take that.
That.
Also, handles few pieces. Okay, sorry, I'll take it after yours. But yeah, let's take consent. Basically, you have asked two questions. On the first one related on consent. Then the third one on how to implement the consent. So the law says consent, and this is very critical, and there's actually a full guideline out there which you can share, or you can pick it from the ODPC site. Consent simply says someone needs to be able, you can't put a consent that someone has no option to refuse. The consent has to have a yes and no answer. And the consequence of that yes and no cannot be coerced, cannot be forced. That means if I say no, the consequence of my no simply will say, okay, I'm not interested in your service because I don't like your privacy standards. But it's very clear that you have explained why your privacy standards or how they are, and I have refused. So consent, the law also insists and says it has to be clear. It talks of Wanjiku. Means whatever document is, it's not terms and conditions. It is the burden of you, the controller, to make it understandable. And yes, you can be found liable if your consent was hidden in the small print. Wanjiku says she didn't understand. If she can prove that actually it's too complicated, I was doing it because I needed an emergency medical loan, so I accepted. They can go back and actually prove that it was not, I was not understanding what it is. So it's still your liability as a controller, Wanjiko's liability. So you need to make it simple, understandable, first of all. And remember, the moment the consent is gotten, it's you responsible going forward as a controller. On all records, you basically need to, most of the cases, the laws came in 2020. We have been given time, and yes, the Commission understands that very well, but she does not expect you to continue doing your old habits, even on old records. Going forward, the technical mechanism around it is, yes, to ask for consent again. But you plan it out and say, we have these records, do you accept we continue keeping them and processing them or not? That's how you do it technically.
Last one here before we finalize.
Thank you. My question is on sometimes we get a request from an investigating agency, like the police. Maybe they want a certain document from your Sacco to prove. Maybe the member is the one in the problem. So when you want to give this document, that actually that is a request to a letter from that agency. When you want to give the document, do you need also to inform the customer or the owner? Or how do you go about it?
Yeah. So a good question also. The law covers the component of investigation, whereby if it's a government investigation or it's a government process or another legal, as long as it's legal, you will not need to inform them it's under investigation. You cannot be sued for it because it was a legal investigation under law, so you did not go and secretly. But if one of your members secretly passes that information to an investigator who is not official, then yes, Wanjiko has a right to say, I do not believe they followed the legal process. And she can sue you. A good example happened where an employee was profiled. He was being employed. So they did shortlisted him. He was one of the best. Then they did a profile and denied him the job after they discovered some bad things. The law he requested for the reasons why. The law actually demands that you tell the person the reason, how you profile, and concluded that it's not the best. So the organization, was it an insurance? A bank, actually, it refused to give him the information of the profile, background checks. And yeah, he got awarded because any data that you collect, remember, this wasn't your data, maybe it's a third party doing the background check for you. But any data you collect on Wanjiko and add on what you already have, all belongs to Wanjiko, and she has the right of access and portability. That means you have to give her when she wants it. So when you are doing investigation, many of those things happen. You might be passing information, but how you manage it in general, policies, map out your processes that involve Wanjiko's data, policies, consider the risks, that's what we call the DPIA, and decide how will we handle such situations.
I just wanted to leave you with something. Privacy is an inherent human right and a requirement for maintaining the human condition with dignity and respect. This is a guy called Bruce who postulated that, or said that. Apologies, I don't have my contacts, or rather my cards, so these are my contacts. You can scan the QR code or pick the phone number and email address from there. And thank you so much for your attention and the questions. They were really great. Thanks.
Okay, thank you very much. Let us appreciate Mercy Barasa, CEO and founder of Roma Services Limited, for the wonderful presentation. Pigeni makofi tu mazuri. Makofi mazuri, asante sana. Thank you very much. You can take time, scan the contacts if you have